Double jeopardy. Can a professional be punished twice for the same professional misconduct? Suppose Mr. Chong is a registered public or chartered accountant in both the United States and Malaysia. Now, while out on a working trip in the United States, Chong is found guilty of professional misconduct in the US. He has paid US 50,000 as fine and he has since returned home to Kuala Lumpur. The local professional body, the Malaysian Institute of Accountants, who regulate the profession, say to Chong, because you were found guilty of misconduct in the United States, you are automatically charged with professional misconduct in Malaysia. Go through the disciplinary process. He does, he's found guilty of misconduct, and he's asked to pay a fine or go through some other sanction. The bylaws of the Malaysian Institute of Accountants confirm this. Now change the facts. Suppose Chong had been found guilty of theft in the United States and had been punished with imprisonment in the United States. He has served his sentence, he returns home. Can he be charged again for the same offense in Kuala Lumpur for a crime that had occurred in the United States? Several laws say this cannot be done, quite apart from the question of territorial jurisdiction. So what is the difference between Chong, a criminal, and Chong, the accountant? Why is the accountant being treated with greater harshness? I could ask the same question about lawyers. Are professionals to be held to the same ethical standard or to a far higher one? Some professional bodies argue that professionals have to exhibit the highest standard of professional ethics. Now that's a good point. The second argument, that it is to be higher than others, is a little more tenuous. It departs from the principle of equality. Professional bodies claim that to maintain a very high standard, Chong the accountant has to be treated more harshly. They say such a view is in public interest. The question is this legal? Does the law support this view? The easy answer is different professional bodies have different rules. But the more difficult question is there a uniform principle at work for professionals? I think there is. We start with international law, the international human rights law. The International Covenant on Civil and Political Rights recognizes under its Article 14, Clause 7, no one shall be liable to be tried or punished again for an offense for which he has already been finally convicted or acquitted in accordance with the law of penal procedure of that country. However, it doesn't apply to prosecutions by two different sovereigns unless the relevant extradition treaty expresses a prohibition. The federal constitution in Article 7.2 has a provision against double jeopardy. Then Article 8 creates a law that all are equal before the law. Not only that, Article 8 Clause 2 states that no man can be treated with prejudice in his profession. That is supported by Article 5, the principle of which is that a person's right to life is inviolable. Chong's professional reputation is a right to life. The deprivation of Chong's reputation is a violation of Article 5, Clause 1, so says a Court of Appeal case. Then there's the common law principle of atrophy equit. This is the starting point in the law. It's a principle that has been recognized since Norman times in England. Double jeopardy has been permitted in England and Wales in certain exceptional circumstances. It was confirmed by the House of Lords in 1964. Now let's deal with a girl called Julie Hogg. Almost 3 decades after the House of Lords case, William Dunlop murdered Julie Hogg. Controversially, Dunlop was acquitted in 1991, but later he confessed to a murder. An Ming was a mother, Hogg's mother. She demanded a retrial, but that of course required a change of law. Then came this case of Stephen Lawrence. In April of 1993, a black teenager, Stephen Lawrence, was waiting for a bus in southeast London. In a racially unprovoked attack, he was brutally murdered by 5 underage assailants. Also, although the 5 suspects were arrested, they were not charged. A public inquiry was held in 1988. It was headed by a High Court judge, Sir William Macpherson. The Macpherson report changed the history of criminal justice in Britain. He found that the Metropolitan Police Service had been institutionally racial. In 2003, the British House of Commons passed the Criminal Justice Act 2003. It became effective in the year 2005. After the change of the law, new evidence was discovered against the assailants. In May of 2011, two of the original suspects, Dobson and Norris, stood trial for the murder, and they were found guilty in January of 2012. Being juveniles at the time of the crime, they were sentenced to detention at Her Majesty's pleasure. It's the same thing as a life sentence against an adult. So why are all these important? For three reasons. In Malaysia, professional misconduct is treated almost as if it's a crime. There is a phrase for it. It's called a quasi-penal procedure. If found guilty, a man is in danger of being deprived of his right to livelihood as an accountant. Second, we saw how the constitutional provisions assist a man like Chong. Because Malaysia's constitutional position is contrary to the Criminal Justice Act of 2003 in the UK, the current UK position doesn't apply here. So what? All these principles, when read in light of the common law and constitutional provisions of equal treatment and protection, the right to livelihood, the right to reputation, and the constitutional rule against double jeopardy in Article 7, Clause 2, are contradictory to the bylaws of the Malaysian Institute. And therefore, the answer is anyone afflicted with this kind of problem should ask the High Court for a finding of double jeopardy. It is my respectful opinion that if a misconduct had occurred outside Malaysian waters and the culprit had been punished for it or found innocent, it would be difficult for a local professional body to punish him again. Thank you very much for watching. I'll see you again in another episode of GKtv. Goodbye.